We're going to call to order the all right. We'll reconvene the Clark County Election Board meeting, today being Wednesday, February the 28th, 2024. We've taken our sign-up list, so I'm going to dispense with calling out the names of the public. We had one motion left on the complaint filed by Clark County Republican Party Chairman Ron Grooms regarding the candidacy for delegate and public or precinct committee person for Ms. Caitlin Blessett. I can simply announce that we received a email from Mr. Grooms that he is withdrawing that complaint regarding both of those positions. So there is no longer a complaint. So it would.
And so, so with that in mind, then I withdraw my acceptance of the complaint.
He
moved, yes,
which was on the table.
I get it. Then, not having a second anyway, the motion, the complaint is withdrawn, the motion failed, and congratulations, Ms. Blessett. I guess you'll be on the ballot in May. So that would be the only other piece of business. I'm going to move that we incorporate this into the meeting minutes for today. Is there a second?
Second.
All in favor?
Aye.
And if you would put that in the record. If there's nothing else,
There
do you
is.
have any other?
There is something else, I'm sorry.
Okay.
Please don't be worried about the length of this, it's just that something I had prepared because I thought I was gonna have to defend myself. So I'm not gonna go through all of this, but I do want you all to take into consideration the other three gentlemen that did not make it through. And I do think that they fall under the same situation that I did to a degree with the due process rights. And I know that we talked about due process being notice and a hearing, but there are very specific definitions of notice. And I know that, for example, in speaking to Mr. Reynolds when he got here, he had no clue what was going on because he had not received his document with those codes. So I do feel like administratively, this was not an example of due process, and that none of those guys had an opportunity to properly defend themselves. So I don't know what needs to happen, but I do think that they all need to be overturned, and that next time, due process needs to be followed. And another thing that I'm a little disturbed about, I'm very happy about this, I'm very happy to make it onto the ballot. But another thing I'm a little disturbed about is Ron Groom's statement that he had substantiated his information with the Republican member of the election board, which would be you, Mr. Singleton. And I'm not sure if he exactly was stating that you advised him that he had grounds for a challenge, but what it sounds like to me is that some sort of conversation was happening outside of public hearing before our challenge hearing off the record. And as you can imagine, that would totally compromise everybody's case. Those conversations can't happen.
No, Ms. Blessett.
Explain to me how that would not be a compromise.
Board members are allowed to take information from anybody that wants to give them. So if he has a conversation with Mr. Grooms, that's completely their business. We can't deliberate off the record.
We can't talk. In other words, I had no idea why he didn't second, and so we didn't talk about it. I still don't understand. So that was, that's what that.
Yeah,
that
the open door law prevents us from deliberating on any of
ourselves.
these things privately. So we can't discuss this stuff when we're not in chambers or on the record together. So
We're talking.
if he wants to talk to Mr. Grooms or Mr. Groom wants to reach out with him, my email's available to the public. I've shared my cell phone with you. You all are free to reach out to me at any time, and the same goes. We serve, obviously, at the recommendation of the party chairman for each of our respective parties. So it's expected that at some point we're going to have a conversation with the party chairman. So the rest of the information, I want to make it clear, that's not deliberation. That is seeking advice, getting information, and conferring with the party chairman. So Yeah.
So this is a quasi judicial system here, process going on.
It
So
is
would that
it
fly
is
for a judge? Would a
quasi-judicial
judge
system.
be able to
It
talk
is
to the challenger
a
off the record?
civil system. So if he files a complaint, there's nothing necessarily that's gonna prevent that. That's not a, what you would call, ex parte communication for the purposes of this hearing. That information he had probably, I'm not speaking for him, but if he received it prior to us going on the record while we're in the meeting, it's expected that you have a right to defend yourself, answer the complaint. If you had needed more time and it was reasonable, I would have made it available. I kept the record open for today, just to leave it so that you could include anything else. This supplemental will go in today's record too. So I'm trying to do the best we can to keep it, number one, as informal as possible, so that the public has the easiest way of understanding what we're trying to accomplish. I don't sit here as an attorney. I sit here as an appointee. So I don't always put my lawyer hat on when I'm trying to read this stuff. I wouldn't necessarily act as my own attorney anyway. That's very bad advice for a lawyer, to be his own lawyer. So when Mr. Grooms was here, his statements are his statements. So whatever he said is to be taken as he said it. So, you know, there's nothing that precludes this board from having conversations with other members of the public.
Sure, conversation's fine, but when you're serving as an impartial decision maker for a hearing and you, basically, Mr. Grooms, can I speak?
I understand, but we
Mr.
have
Grooms
enforcement
had
powers
access-
also, so
Right.
I can come down here and I can ask the staff, I need to know, I've heard some information. Can I get some information about who so-and-so's voting record? Have you got this information? So we're entitled to pull that stuff up. So if he has some kind of conversation and says, hey, are there people getting challenged? And Mr. Singleton pulls up the same list of candidates and looks through it and says, these people are eligible to be challenged, that's completely within the bounds.
Well, it sounds like legal counsel to me. It sounds like Mr. Grooms had access to an attorney for free, which I did not.
No.
And the rest of the people did
No.
not. Okay, so you're saying that it is okay for, Mr. Steele, are you saying it's okay for
Here's
an
the-
impartial board
here's
to
the
have a
issue, Ms. Blessing.
conversation?
There's nothing else that we're gonna be able to do, okay? You're back on the ballot, right? So
The
that's
others
great.
are not, and I don't think that it's right.
You know what? They were here, they had their opportunity to respond, they haven't asked for an appeal, and their time for that closes tomorrow at 12 o'clock.
Were they notified of that? Do they know they can appeal tomorrow?
It's understood that if that's the law in the state of Indiana, and we're trying to do our best to interpret it, it's not there's no quote final order, we simply denied their access to the ballot. You don't have a constitutional right to run for office, okay? And you don't
You do, actually.
No, you don't.
Okay.
From the lawyer, right? You have a constitutional right to vote, right? But to be an officer in any political party or to run for any political office, you still have to meet certain requirements. That's the rules. So,
Do you understand that due process didn't happen because notice was not given? Mr. Reynolds did not even have a copy of this
I know that our
document.
staff notified you and the other people that were challenged 2 weeks prior to the hearing yesterday, on Monday, when we met. So 2 weeks with notice and the deadline, I think, is plenty of time for you to be made aware.
A phone call is not notice. If you went into a
If you were
courtroom,
notified,
if you went into a courtroom,
This
what
is
would a
still an
judge say to
informal
you without a
hearing.
document?
This is not a courtroom, and this is, the rules of evidence don't apply here. Okay?
Really?
Yes.
Because under the 2024 candidate guide,
No.
it does point to Administrative Procedural Act.
I understand that, and by
And
publishing
service
our
of
meeting
process is
and
in
making
there.
it known, we serve notice. Okay, so there are different rules here, is
Do
what
you-
I'm trying to
Are
say.
they documented anywhere? Because just saying that there's
The Indiana
different
State
rules
Code that
here,
we had open, the APA, the Administrative Procedures
where does
Act.
it say a phone call is sufficient?
You were here on Monday, correct?
Yes, I
Okay,
believe
so
you know
you
that I
had
was.
notice. At that point, you're not challenging any other jurisdiction of this board. You're not challenging whether or not you had notice. You were here. And you were given every opportunity to make your statements and submit information. Same as Mr. Grooms.
I'm not talking about me necessarily. I think an injustice has been done. I think you know that due
I
process
encourage
didn't
you.
happen.
I encourage you to talk to an attorney and find out more about what you believe can be done about it, okay? Because there isn't anything else that we're gonna be able to do about it. The complaints were valid, they were filed, notice was served, everybody that was challenged was present here and was able to give a statement. We voted by applying the law. If they were kept off the ballot, that was the ruling.
Okay, well, in the event that they do want to file, an appeal or
I would
whatever.
recommend that they each talk to an attorney on their own.
Okay, well, that'll be up to them, but I would like to ask Mr. Singleton directly, what were the conversations that you had with Mr. Grooms off record about these challenges?
He asked, what the grounds were for a challenge. I instructed him that the same thing we went over and over, yesterday or 2 days ago. And I further instructed him that, if he, as chairman, has the right to let other people that don't qualify under the first part, if he believes them to be, if he believes that they should remain on the ballot, he has every right to do that as chairman.
Okay, so you did provide him some guidance
General
on what
guidance
he
that I
could
would-
do.
The general guidance, the same thing I mentioned to you after the meeting, it was, yeah.
That would be appropriate.
That would what?
That would be appropriate.
Yeah. There hasn't been anything done illegally. I know that you may
I don't agree
think
with
so,
that. I think you
but
all really need to look at this process moving forward. Just because this is the way things have gone prior to this, I know what service of process is. So moving forward, somebody
I
needs
will
to
take-
make sure that these
As the
people get
chairman,
their
I will
documents.
take that under advisement, and I will give it deep consideration as we go forward, okay?
Okay.
All right. With that being said,
Can I ask a question about the three? You said they had till noon tomorrow to appeal.
we have to have this up to Indianapolis, I believe, tomorrow at 12? Yes.
So
Okay.
they would have to do it before that.
I would expect if they wanted a hearing from us, but we're not gonna be in regular session again after today.
So
So-
they don't have time really to do that. And
They would have to ask for some kind of, I would expect them to file it with a court to enjoin us from certifying the list of candidates.
so somewhere here in this building, follow with somebody here in this building.
Yeah, I would suspect it would be with the clerk, and they would have to get a cause number and file any other kind of special
So
action.
they would, okay. So if they wanted to do that, they would have to do that first thing in the morning.
I suppose. You're
I'm just-
asking me for
I'm-
legal advice. And
Well,
I'm trying to be as forthright and as friendly about it as possible, but I can't advise you anymore. I mean, if they were going to do it, the best advice is to talk to an attorney, one. Number two, if they are going to try to seek some injunction from us sending this information to the IED up in Indianapolis by our deadline tomorrow, they would have until 12 tomorrow to make sure that they got it to either a judge to send us an order or something. But, other than that, that's about the best I know.
that's my own curiosity, if
I understand.
if somebody wanted to call and let them know that. So, thank you.
I'd just like to reiterate what Caitlin said. I agree with her because I just feel strongly that they all four were challenged based on the same thing, the two primary rule, right? And if we're going to withdraw and say Miss Blessed, which I'm glad it's been withdrawn, and are allowing her to run even though she didn't qualify under the two primary rule, the same should be done for the other three. Because otherwise it's discrimination.
That's,
And I'm sorry, let me finish. You always interrupt, but
I
let me finish.
understand, but we had one item on the calendar today, and this is now becoming a discussion about something that we've already ruled on. And I want you all to be able to make
I
your
understand
statements.
that, but I'm making a
If you want to include them
statement.
to us, please go ahead and put them in writing. I'll be glad
Well,
to
I'd
read
like to
them.
make it on the record so the people can see.
It will be
You know-
put in the record.
Anyway, let me finish. you know, and those other 3 people, you know, are not the only 3 that didn't meet the 3 primary rule. Ms. Blessett gave you a list and found even more after that also didn't meet that 2 primary rule.
But there were no
And they weren't
challenges
even
filed.
challenged. Why? Because it's selective targeting against certain individuals, and that is what is so wrong with this process.
Well, you had people, people had in those districts also have a right to challenge. You don't just have to be the chairman.
But we didn't know who was going to be challenged until the deadline.
Well, you're never gonna know. I mean,
You have to
if you
file
wanna,
first.
you need to, go ahead and file. If you've got a problem with somebody on the ballot, file a challenge. Everybody has that right. And the chairman has the right to do it for everybody, or anybody on the ballot. But if you live in a district, or if it was an at-large candidate, you're a voter. You could have challenged it if you felt like it needed to be challenged. Everybody has that right.
May I?
Yes, ma'am.
So,
I'm sorry. Go ahead.
okay, so my question is, those people that weren't challenged, did this office receive certified letters about those candidates that weren't challenged and
No.
did not have the
No.
2? Y'all didn't receive any letters at all from Mr. Grooms
No.
certifying those? that
Nobody
didn't-
challenged them.
Okay.
If somebody had challenged them,
No,
no, I know.
regardless of whether,
Let me finish.
that wasn't.
If
okay.
somebody challenged them, that would be the appropriate time for Mr. Grooms to send a letter or show up and say, no, I give that person permission.
I disagree, because the law states, I mean, you all are
Guys.
talking about the law, I know, but
I mean, seriously.
I just want to clarify and make sure I've got the answer. So those people who do not have the 2 primary vote for this upcoming Republican precinct committee man any of the candidates, but they were not challenged, nor were they an attachment letter, whatever the form is that the chairman signs, was not attached.
No.
None.
Mm.
Thank you.
Okay, one final thing, and I'm done. Does Mr. Grooms have any ability to withdraw after everything's been decided on? Like, what if he goes back and says, I withdrew my challenge for
I
Ms.
don't know.
Blessed, so.
I mean, as far as I'm concerned, the board voted. We accepted the complaint, vetted the information, didn't meet the 2 primary rule, and didn't have extra permission from the county chair, so we voted. Now,
take the win.
in the future, maybe, I don't know, but that's really not in front of us at this point. There's a whole lot of if-buts from you guys.
No, I'm saying by
that I'm trying to
tomorrow.
understand the reasoning for the
I'm asking
question.
by tomorrow, like, if Mr. Grooms were to say,
We're
hey, I
not
wanna.
meeting before tomorrow.
I state-
Okay,
I state
well, I
law
didn't
is
know
So
if he could
this
just
will be
submit something,
sent.
that's my
It's
question.
You know,
If he
It's
could
on the
last
just-
record.
evening, they announced the decision in Mr. Russ' case, but they also had the regular meeting for the commission up in Indianapolis, and they decided on several cases. There's nothing in the news to indicate that somebody's gonna be beating down a courthouse door to try to challenge the Indiana Election Commission on the candidates that they determined up in Indianapolis. So, I mean, I've been doing this for over 10 years, and this is the first time that we've had challenges of this kind of nature that I can recall where these kind of arguments are getting made. So, I mean,
It's a new day.
I
Well, the
tip my
law
hat if
did
you all are
change
being
3 years
creative
ago.
about it. And again, I'll take it under advisement regarding notice. I don't disagree with you necessarily that this process seems unfair to a layperson or anybody that's walking in off the street. But this is all established in the statute, and we try to run this according to the rules for open laws. Can't meet in secret, can't deliberate off the record. And I mean, I try to strictly adhere to that rule, because if I don't have any credibility when we're making these kind of decisions, I mean, we ain't friends, right? So I don't have talk with him about this kind of stuff off the record. It happens here, it stays here, so that everything that I put in, you all can read exactly my thoughts on it. This is getting recorded right now. So we can go back, and you can always submit something to the board in writing. And it's not that I'm trying to cut you guys short, but we literally were only here to decide one issue today. It's not our regular meeting, and I'm glad to take as much as we can, but
You're ready to adjourn, in other words.
yeah, I gotta pee.
We gotta eat.
No, I mean, that's the way it is. And I'm sitting here looking at the clock and we've gone over.
Yeah.
And that's, I'm trying to be fair and give everybody
And you are. Thank you.
a floor, but I do have to use the
Well, on behalf
restroom.
of Caitlin and all of us, we want to say thank you for doing this because
It was,
I feel like it was the right thing to do, you know?
Well, given
all I could
opportunity
do, we didn't have a
to
vote.
speak.
We didn't have a second, so I have to leave the motion open, in my opinion, to give it more time to breathe.
Sure.
Mr. Grooms made the decision. If you all want to write a thank you note to him, that's who I would direct that to. Because I'm only sitting here, after yesterday, it was very clear that Mr. Rust is not going to be on the ballot. So,
Well, the election board voted no, so.
not just the election board, but the
Yes,
Supreme
the
Court
Supreme Court-
decision
the
is
Supreme Court
also
denied
upheld.
his
So
appeal,
that
and then
rule
that
is
went to
a
election
bright
board.
line test. It really didn't leave me a whole lot of place to go. So if we would have been back here today and there wouldn't have been any other information, I was gonna have to vote to uphold the rule anyway. So Mr. Grooms is the person that decided to stop. So,
Well, I just say it's a shame that the Clark County Republican Party did this.
well,
You
I'm
know,
not a Clark
it's,
County
I know you're
Republican,
not, I know, I'm
so
just putting that
please
on
do not
record. It's
associate
a
me
real
with that
shame
kind
because
of
I've been a
stuff.
Republican for a long time and I hate to see them do this. Pick and choose who they're gonna target and challenge and let others that they like get a free pass. That's just wrong.
I
That's my
encourage you to
opinion.
continue to
Sorry.
be active in their party and do whatever you wanna do to break it up. I mean,
We will.
absolutely. Get organized and go out and cause people problems. I encourage it. That's the best way to be politically active. This isn't a hobby.
It is for me.
It's not a hobby.
Yeah, it is.
This a
It
life.
consumes all of my spare time pretty much.
Well, I'm saying, I
I'm
mean
very
it seriously.
sick. I'm very sick in the head.
Watching
Mr. Steele.
MSNBC or Fox News
I
and
don't.
getting stirred up on issues is not how we accomplish anything. It's being here in these meetings, it's making sure that you work the
Absolutely.
polls, which is clearly
100%
not a hobby.
I think it's a
Absolutely.
shame Grooms didn't show up
So-
today.
Being informed on political issues is a hobby.
I know.
I care too much.
I get it, but I'm saying, you're doing more than what you think. It's not, it's more than just a
I
hobby.
put my name on the ballot.
Good job. If there's nothing else, I am gonna move, we're scheduled to meet for our third Monday meeting in, March. We have no other deadlines that I believe are impending. So, I'll just move that we recess until then.
Second.
All right, and then, all in favor?
Aye.
Aye. All right, thank you all.
Thank you.
Congratulations.
Thank you.